Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and we have cases where we defend consumers who have been sued by a debt buyer, and we win those cases. Well, what do we do next? And a lot of you guys have reached out to me and said, hey, I'm planning on winning my case, or I won my case last week or last month or 6 months ago. What do I do since I've won my case? And I thought, I've covered this a little bit in other videos, but I don't think I've ever done it kind of step by step by step. So there's really 12 steps that we follow in my office, and I hope that you get some value out of this. So if you are either planning on winning your case or you've already won your case and you're interested, then join me on this 12-step journey and we'll see where we end up. All right, so here's the overview, of the 12 steps. So we're going to talk about what does it mean to win your case? Did the debt buyer appeal? Have you pulled your credit reports for free? Is the debt buyer on your reports? And even if the debt buyer is on your reports, can you match up the account sued with what's actually on your credit reports? And does the account show up as disputed? And do you want to look at suing now or doing a dispute through the credit bureaus? If you do a dispute through the credit bureaus, make it a very specific dispute. And if you dispute through the credit bureaus, make sure that you can prove they received your dispute. And then, did you get the results back? And is it on there or is it deleted? And then, do you want to sue under the Fair Credit Reporting Act, the FCRA, and the FDCPA, Fair Debt Collection Practices Act? So let's go through these quickly. So number one, what does it mean to win your case? Well, at least where I practice, and really every state I know of, and I've had a lot of people reach out to me and say, hey John, I won my case, and they've done some or all of these steps and they're ready to sue. And so we'll get together with local counsel in their state, and then we bring those suits. And so this is what we're looking for. Two things. Number one, a judgment in your favor. It'll say, a trial happened and judgment in favor of defendant, or judgment in favor of Sue Smith. Or it's a dismissal with prejudice, with prejudice, not without. We've talked about that in other videos. With prejudice. Usually this means you show up, maybe they don't show up, or they show up with no proof, and the judge, just instead of saying judgment in your favor, just says dismissed with prejudice. Or maybe they come into court and they go, Judge, we want to dismiss with prejudice. We give up. It's the same thing. So that's step number one. Number two, you have to, it's great to win, judgment in your favor or dismissal with prejudice, but then did that debt buyer appeal? They may have sued in small claims court, sometimes it's called magistrate court or general sessions court, and they have the right to appeal to the higher court. Maybe it's called circuit court. So number one, did the debt collector have the right to appeal? Normally they will if you have won your case. And so if the order says there is no right to appeal, well, then that's probably not a victory. So almost always they're going to have the right to appeal. Well, did they appeal? And see, a lot of times people will say to us, no, they didn't appeal. I say, well, did you check with the court? They go, well, no, I just assumed I would know. Well, you should know. You should get notice, but that doesn't always happen. So it's good to call the court, say, hey, here's my name, here's my case number. Do you see where I won the case? Oh, yeah, I see that. Is there any appeal? Did they file anything after that? They go, nope. Well, as long as you know how long they have to appeal and it's beyond that time period, then you can be, certain that they did not actually appeal. So let's go to step number three. Pull your credit reports for free. And sometimes people say, well, I already pulled them, a month before. Well, pull them now, Particularly if, let's say you won your case and now we're 30, 60, 90 days out from winning the case, pull your credit reports for free. Go to annualcreditreport.com. You can do this through April of 22. It may go longer than that, but right now, as I'm recording this, March of 2021, it's at least through April of 2022. And here's what you want to pull. Equifax, Experian, and TransUnion. Now, if you can get Innovis, which you have to go directly to Innovis, or SageStream, those are great, but the big three you definitely want to get through annualcreditreport.com. Now you may say, well, I have a Credit Karma account. That's great. Save that, document that, but still go pull from annualcreditreport.com. You say, well, I have a MyFICO account, or I have Smart Credit, or Identity IQ. All that's great, but go to the source, get your real actual reports. Okay. Now you could also go to transunion.com, Experian.com, Equifax.com, but sometimes you have to pay for it there. It's always free through annualcreditreport.com. Here's the key: save to PDF. So many people pull up their report and they go up in the navigation bar and they copy the URL and they go, there it is. It's like, no, that's not. That's the URL sort of for everybody. Once you log out, it's gone. Okay. So if you don't know how to save to PDF, research this. Just get on YouTube. You're on YouTube right now watching this. Just watch on YouTube. Say, how do I save a document to PDF? Figure it out, whether you got a Chromebook, a MacBook, a PC, whatever you have. Make sure you know how to do it, so when you pull up those reports, then you can save them to PDF. Okay, what's the next step? Well, very simply, you go, is the debt buyer on there? So Midland sued me. I beat Midland. Is Midland on my credit report? Could be Midland Credit, Midland Funding. Portfolio sued me. It might be Portfolio or PRA. So sometimes you have to look at it closely, but do you see the debt buyer on there? Okay. Now, we don't stop there, okay, because there's another step. We have to match up the account that we were sued on. So Midland sues me on a $5,000 Synchrony bank account. I beat them. I then pull my credit reports and I see Midland. I go, oh my goodness, Midland's on there. And you say, yeah, John, but it's an $800 Capital One account. Oh, it's not the same thing. So we want to match it up. Well, how do we match it up? I have a few things listed here. Is a dollar amount the same or almost the same? How about the original creditor? If when you were sued, if the lawsuit says this is from Synchrony Bank, and then the account on your credit report says original creditor Synchrony Bank, the amount is $5,000. How about the account number? They may attach some of the account numbers, okay, from the original creditor. Now, you typically won't see the original creditor account number on your credit report, but maybe the original creditor is on your credit report. Synchrony Bank or Capital One. You can sort of match it up there, look at the dates, compare the dates with Midland or Portfolio. And sometimes the lawsuit from Midland or Portfolio, or maybe a letter you received, will have the account number for Midland, Portfolio, LVMV, whoever it is. You match that up. Basically, you want to look at everything you have, okay, over here in the lawsuit or in letters, and then compare that with the credit report. Usually it's pretty easy. I mean, if you have a Synchrony bank account for $4,097 and the lawsuit was for Midland Funding, Synchrony Bank, $4,097. You know what I mean? It's like, okay, that would be a really weird coincidence, okay? And just make sure I said the same thing. It's the same debt buyer on the lawsuit and the credit report. And so if you have questions about this, you can reach out to me, reach out to a consumer lawyer, and have us look at it, because, I mean, this is what we do a lot. And so we can tell usually pretty quickly, yep, same account, or wait a minute, that's not the same account. Because I do have a lot of people call me that say, hey, John, you won this case for me. It came off my credit report, and a year later, it's back on there. And I look, and it's totally different. Different original creditor, different account number, different amount. And I'm like, well, we beat Midland, but that doesn't mean Midland can't go get another account of yours. So again, we have to look. All right, what's step 6? Is we look at, all right, since this account is showing up, is it showing up as disputed? So does it say like consumer disputes, disputed by consumer? And the significance of what we're looking at here is when we answered the lawsuit, we denied it, we disputed it, And then the debt buyer, when they update the report, they have to mark it as disputed. If they don't, that's a violation of the law. Now, the account being on there is almost certainly a violation of the law. Okay? So you won your case and then it's reporting on your credit report. That's a violation of the law. Now, if there's 1 day difference, maybe not, okay? But if there's 30 days or 14 days or enough time, that's going to be a violation. But you also just want to know, kind of put in your back pocket, say, you know what? I've got them for the failure to mark my account as disputed, even though I disputed it in my answer 2 months ago or 3 months ago. All right. So we're about halfway there. Let's look at step 7. You sort of stop for a moment and you're at a little bit of a fork in the road. You say, all right, I won my case. It's still showing up on my credit report. Maybe it's disputed. Maybe it's not disputed. Do I want to sue now under the Fair Debt Collection Practices Act? Or do I want to do a dispute through the credit bureaus to give them an opportunity to fix this under the Fair Credit Reporting Act? So let's look at sue now. If you won your case and you don't owe that debt, what's it doing on your credit report? Now, again, if you won on March the 17th and you're pulling your credit report on March 18, it's a valid basis to dispute it, but I wouldn't sue over because it stayed there 1 day. Okay. So assuming enough time has gone by, we look at 1692E. That's the misrepresentation. There are other sections, and specifically there's 1692E8, which says no false credit reporting. Well, if I won my case and I don't owe the debt, and sometime after that they're reporting that I owe it, that's a problem. And if they don't mark it as disputed, that's a problem under 1692E8. All right, well, what about disputing it? So remember, we're at sort of this crossroads, and we could sue now or we could dispute. But if we dispute through the credit bureaus, just remember, we still have this. I mean, if I won my case and some time goes by and they're still reporting, well, then I've got them on the FDCPA. So I can dispute through the credit bureaus. Even if everything gets fixed, I can still sue the debt buyer, or at least consider suing the debt buyer under the FDCPA. So we can dispute it through the credit bureaus. Maybe they'll delete it. Maybe they'll keep it. We can figure out about that. And we may be able to, if they keep the account, we will be able to sue under the Fair Credit Reporting Act, the FCRA. All right, so let's talk about the dispute. However we're disputing it, we want to do two major things. Identify the account and then explain why it should be gone. So how do we identify the account? I've got a few things listed here. The name, the account number, the amount, the date open. I mean, whatever you can look at your report. Some people will even take that page of their credit report that has Midland or Portfolio or whoever, and they'll attach it in their dispute letter and say, hey, look at what I've attached here. This is from your credit reports. That's the account I'm talking about. Well, why should it be deleted? I was sued. I denied owing them. I won. I got a judgment in my favor. I got a dismissal with prejudice. I want this off my report. I don't owe it. Okay. You may want to attach the complaint. That's the lawsuit against you, the order. Hold that up where you won. You may want to give the account number, the case number, the court information. So you say, I was sued in the small claims court of Jefferson County, Alabama, or Shelby County, Alabama, in case number 2021-DV-900123. Okay, great. Now you've done that. Now, if the credit bureaus want to, they can investigate this. They can call the court, right? Midland or Portfolio or whoever sued you, obviously they know what case they sued you in because they sued you. So they can easily find this information. All right, well, what do we do next? Well, when we dispute it, we want to make sure we can prove that the bureaus, each bureau received our dispute. It's really, really critical. So if we do it by mail, send it by certified mail. If we do it online, do a screen record, just like I'm doing right now. I'm recording my screen, okay? I use something called ScreenFlow. You can use Snagit. You can use Loom. You can even use Zoom, okay? Just kind of do a Zoom with yourself and share your screen, record it. If you're doing it by fax, Get a fax confirmation. If you're doing it by phone, I don't recommend that, but if you are, either take incredibly detailed notes, or if when you call they say all calls may be recorded or monitored, well then record the call. Okay. Point is, you want to be able to prove that these guys got your dispute and exactly what you disputed. All right, now number 10. Did you get your results back? So you pulled your reports, you saw that account on there, you disputed it. You should get the results back by mail. But if you have an account on like myequifax.com, Experian.com, even TransUnion.com, you might get the results electronically instead. So just be looking for this, okay? When they receive your dispute, normally they're going to complete their investigation in 30 days, but it can be 45. So just assume 45. So if you don't get results back, say in 50 days, right? Because 45 days and then they mail it, you may want to call the bureaus, or, and I always recommend this, whether you call them or not, pull new credit reports. Well, where do you pull them from? Annualcreditreport.com, right? Just what we did back here. Go to annualcreditreport.com. Pull those reports, save them to PDF so you have exact copies of what your reports are showing now, let's say 50 days after you disputed. This is assuming you haven't heard anything. Now, if you have gotten results back, I still like to pull them just to make sure, you know, they didn't do the results on this day and then the next day delete it. Just pull the reports. All right, so let's go back now. And so again, you want to save those results, save the new reports to PDF. Now, step number 11. You get the results, you get the new credit reports. Is the account on there? Okay, is it on there? Well, if it's been deleted, we can't sue under the Fair Credit Reporting Act, whoever deleted it, okay? But we still may be able to sue Midland, LVNV, Jefferson Capital, Portfolio, whoever, under the FDCPA. Because if we won our case and then they continue to report, that's easy, okay? We may even be able to sue them for the previous reporting before they lost their case. Because when you win your case, that means you do not owe the debt. So why were they reporting it back here? Now, that's a little more subtle, a little more complicated approach. Definitely don't do this on your own. Get with a lawyer who does this type of work. Not somebody who says, oh yeah, I'm thinking about that. That'd be a great area to know. Get somebody who does this type of work. And they have to understand the law in your state, your jurisdiction, and whether or not this will be successful. But check that out. Now, if the account is still on there for Equifax, let's just start there. Then look at suing the debt buyer under the FDCPA and the Bureau, Equifax, under the FCRA, and the debt buyer under the FCRA. Same thing with Experian, same thing with TransUnion. You might have all three keep it. Well, guess what? You sue all three. I've got a number of lawsuits like that right now where we sue the debt buyer and all the bureaus. But it could be that two of the bureaus delete, one keeps. Well, then you sue the debt buyer and the one bureau that keeps it. What if two bureaus keep it? You sue the debt buyer and the two bureaus that keep it. All right, well, what are we suing for? So on the left-hand side, I have the FCRA. So the debt buyer, Midland, Portfolio, LVNV, whoever that is, they are the furnisher. So we sue them under Section 1681 S2B, okay? And that is when they get notice of a dispute through the bureaus. You can send it directly to them, but they have to get it through the bureaus. And they do a lousy investigation, that's what you sue them for. And then each credit bureau or credit reporting agency, same thing, that keeps the false account, then we look at suing them under Section 1681 EB, that's what's called maximum accuracy, and Section 1681 I. I stands for investigation. And we have videos on this you can look up on our channel. The damages, emotional distress, economic damage, those are called compensatory damages, both of those. And we get attorney's fees. If we have proven that it's willful or reckless or wanton, then we get statutory damages. We get punitive damages. Okay, so it's a really powerful law. How about the FDCPA? Well, we look at Section 1692E. That's when they do any type of lie. In 1692E8, that's the same type of false credit reporting. Well, that's the natural thing here. Well, what about 1692F? That's where it's unfair what they're doing. So was the lawsuit itself fair? Is it fair to credit report afterwards? Are they abiding by the contract when they are credit reporting on us when a judge says we don't owe the money? Maybe. How about section 1692D? That's more of harassment, abuse, just being completely sort of a jerk to us, okay? Well, I don't know. It seems like if they're credit reporting that I owe $5,000 when a judge says I don't owe $5,000, isn't that oppressive, harassing, abusive? I think it is, okay? So consider putting that in there. Damages, emotional distress, economic damage. Again, those are compensatory or actual damages. And then statutory attorney's fees. What we don't get is punitive damages. Now, there can be state law claims. We sue for malicious prosecution against the debt buyer. But typically against the credit bureaus, it's just going to be the FCRA unless you have a state law version of the FCRA that survives what's called preemption. Just not to get bogged down in details, the federal law will preempt or push out a state law, but there are some exceptions. So I hope that these 12 steps are helpful to you. I realize this video has gone a little bit long, but I just wanted you to see kind of the process. First, did I win the case? Was there an appeal? Let me get my credit reports. Is this on there? Can I match it up? Do I dispute? Do I sue? If I dispute, be very specific. Get your results back. Is it on there? Is it gone? Figure out what you're going to sue for. And I appreciate you guys watching this. If you have just general comments, put those below. If you have specific questions you want to ask me, just reach out to me through my website, alabamaconsumer.com. alabamaconsumer.com. Okay, guys, you have a great day, and I will talk to you tomorrow. Bye-bye.